So this is an overview of the first two topics of the corporate finance course for revision purposes. And as you can see, I've got the Moodle site on my screen, and these are the topics that we covered in Michaelmas term. We had an introduction, and then we had week 2 and week 3, and I'm going to, in this recording, talk about the general themes of use and abuse of the corporate form and initial legal capital and alternatives. Now, scrolling down here, I've got the slides for week 2 and the slides for week 3 in here. Let me just go back. Hang on. Where are they? Here they are. Boundaries of the corporate form. So that was week 2. And there the main question is, are there any limits for which the corporate form is available? So are there limitations to the availability of the corporate form? And you'll remember that we started this discussion by talking about how historically the corporate form came about, and that was for specific purposes, and then the law opened up and now the form is generally available. The very tricky question is, what about corporate groups, where we've got a situation where a very large multinational enterprise is incorporated in a sort of large number of different entities, and that is done with a view to managing liability. And the question is that legitimate? Is that illegitimate? When is it legitimate and when is it not? We then looked at the tools that set boundaries to the corporate form, and we discussed them in detail. And so one theme is negligence, where sometimes a parent company involves itself in the operational activity of a subsidiary, and then the parent will be liable as a joint tortfeasor. This is the rule in Petro dell'Imprest, which allows veil piercing when a company is used to avoid an existing obligation or to deliberately evade an existing obligation. And it's a very narrow exception. And then you'll remember that sham and facade used to be what we thought of as an exception, but it has now been considered by Petro dell'Imprest to be unhelpful as a tool, and Lord Sumption would like to have it replaced with evasion. And then we talked about companies as trustees, and sometimes statute allows for the piercing of the corporate veil. And here you see other tools that set a boundary, which we discussed. We spoke about agency. This is a mechanism available in German law, so that's a statutory liability of a controlling shareholder in certain circumstances. And one of the questions that's worth asking, is that something that's useful? Should there be such an override for limited liability? And we also spoke about fraudulent trading and directors' disqualification, and I mentioned Phoenix companies. So these are the tools that we discussed, these two slides. And the question for you is to think about, how do we strike an adequate balance between, on the one hand, making available the very useful tools of the corporate form and the limited liability, and on the other hand, working out who are the vulnerable constituencies. And of course, who comes to mind are tort victims or creditors such as employees with limited bargaining power. Now, Moving on then to week 3. Let me scroll up. Here it is. So this is about initial legal capital and alternatives, and continues the theme. And here the question is, given that we make limited liability available very broadly, should there be safeguards for creditors? And the safeguard question is making available legal capital. So rather requiring a certain amount of capital. And there the question is, so what is it we're trying to stop? Well, what we're trying to stop is companies that are incorporated and aren't really viable. So they're kind of bound to fail. Who needs protection? Well, creditors who can't help themselves. So these would be tort victims, these would be employees. So creditors either because they don't know that they'll be a creditor, or they don't have bargaining power. How shall we do this? So why do they need protection? Well, because they can't help themselves. And the question is, how shall we do it? And that is the topic that we're looking at here. So minimum capital has traditionally been perceived as a mechanism designed to helping creditors. It's an ex ante mechanism, so it's designed to be prophylactic. And for it to work as a prophylaxis, it would have to be a meaningful amount, which presently in very few jurisdictions it is, except for banks and other financial institutions to whom the Basel regime applies. So for them, minimum capital is a meaningful prophylactic tool because it corresponds to the risk profile of the bank. Another way of explaining minimum capital is skin in the game point, which means that if you set up a business, you need to put in some of your own efforts, own money. You need to have something to lose. But that skin in the game point, I don't think is a valid one. Definitely, who uses limited liability needs to make to want it to work. So they need to have an incentive for that business to be a successful business. The question is, do they need minimum capital, or is it enough to just them spending their time doing this entrepreneurial activity? So it's a question of opportunity cost. Are the opportunity costs enough to provide skin in the game? And then there, these other measures, so for example, fraudulent trading or wrongful trading, these are exposed measures. So these are measures where we don't have any prophylactic tool, but what we do is we say we penalize people who use limited liability irresponsibly, either because they're fraudsters, and then very obviously they are liable for what they've done, or because they're reckless. And then wrongful trading has a definition of what is considered reckless. So that's an ex post mechanism. And there's liability of directors, and there are 2 cases here, more on directors, but also of shadow directors. So these are then tools that you apply when a company fails, and you look at what has happened and you reimpose liability to the extent that the individuals using liability have been negligent in using it. And here are some examples of shadow directors. Something similar exists in German law. That's the liability for the delay in starting insolvency proceedings, and the tools are designed slightly differently. The overall aim is for both of them to have an ex post mechanism in reviewing the irresponsible use of limited liability, and that's always necessarily done in the context of insolvency. And then here's another mechanism which has not to do with requiring anyone to pay damages. That is an administrative tool, which is the disqualification of a director who has shown that they're unfit to be concerned with the management of a company. So context here is to say anyone is welcome to use limited liability, but if they have been unsuccessful in using it, we will look at whether or not they have been irresponsible. And the test for irresponsibility is unfitness. And there's, of course, jurisprudence to that. And it's enforced by the Department for, no, it's not actually not anymore the BIS, but the BASE. So that's a government department. And the final one is, or not final one, there's two of them. There's the UK approach and the German approach, which is a liability towards creditors. So giving creditors the opportunity to enforce breaches of duties by the directors. And that is done in the UK through the company. So the insolvency practitioner who comes in would be able to enforce these duties on behalf of the creditors. The German liability gives a direct claim to a company creditor in certain circumstances. So that's sort of an additional ex post tool where you reintroduce limited liability, again for negligent behavior, and give a claim to the creditors, either mediated through the company in the UK or allowing creditors to claim directly. And then, of course, veil piercing, which we discussed in week 2, is another way of managing irresponsible uses of limited liability. So what are the takeaways from those 2 weeks for revision purposes? Well, what we want to do is encouraging the responsible use of the corporate form. And for this list or basket of tools, what you need to think about is how are they different from each other? How are they different from legal capital? And then the question for you to think about more generally is, how do we best encourage entrepreneurial risk-taking and prevent at the same time abuse? So where do you draw the line? Which tools are effective? Which ones aren't?